There's no way.
All right, thank you for that. I know the court reporter appreciates the break, and everybody else could have time to get comfortable, so good. Mr. Wade, let's continue then with your testimony so that you have time to wrap up with all of your
Yes. Can I share my screen?
Yes.
First, nice. All right, so share screen. So how do you start broadcast? Okay.
If you just hit that, yeah, there you go.
If I say stop share, will that stop everything?
It will stop your share. They won't take you out of the Zoom room. It just stop your share.
Yes, ma'am. So I just want to point out that during this whole thing with the appeal after the decision from the judge, I had 5 days to appeal, and I basically submitted my statement of inability to pay. But last minute, they tried to change it. If I zoom in over here, they asked for 1,356, and I basically clarified. I had to call. I literally left work. I was about to go pay this money and everything like that, and I had to call to verify because they told me initially, since they sued for right of possession only, I wouldn't have to pay anything. Called, clarified, got
Your
that.
Honor, I'm gonna object based on hearsay.
Well, I'm about to show you. You should have waited. You should have waited 30 seconds.
No, Mr. Way. She has a right to object when she wants to object, as do you. It's okay. She doesn't have to wait. She can object. I'm going to sustain her objection because whoever told you is a hearsay statement. So that's a legitimate objection. I will sustain it. Please don't tell me what anybody else said. The exception, though, one of them to that rule is you can tell me what the representatives from Estancia may have told you, but not some other person you've not identified. So this is sustained for that reason. Let's move on and just give me the facts. I'm right. Right. Just this part of the process, the evidence phase, is where I get the facts. And then in closing argument, you all can argue the law to me and then I'll make a decision. But right now, I just need the facts. What happened? What'd you do?
Well, it's a fact that after I corrected them, they went ahead and changed it back, and I didn't owe anything. And then after that point, they actually signed off on Estancia Villas right there. After they corrected it for not the 1,300.
Well, hang on. If you'll go to that, I see that document, but you scrolled pretty fast. I couldn't read the other two. So I see this one. And just for the record, stop. Hold on. Go back down a little bit. Just for the record, the document that Mr. Way is showing us on the screen right now. Can you scroll down just a little bit so I can better?
Yes, ma'am.
That's good. He's showing us on his share screen tenant's notice to appeal for non-payment of rent, dated, it has a date of November 21, 2023, and then signed by Mr. Way. Go scroll down and let me just note the next one. The next document that he's showing on his screen is entitled Notice of Appeal with Statement of Inability to Afford Appeal Bond / Surety Bond, signed by Mr. Way, also, or has his, what appears to be his signature. And dated also on, looks like November. I can't tell if that's the 27th of November. Is that what it says?
Yeah, let me clarify for you. So on the 16th,
that's better. Hold on. Just let me note what they are.
Yep.
November 27, 2023. Thank you for blowing that up. Scroll down. I'm going to tell her, note the third one. The third document is in title. It at the top says confidential is kind of the title of the document, if you will. Dated November 21, 2023. It is on letterhead of Judge Sylvia Holmes, Justice of the Peace, Precinct 3, Travis County, in this cause number. And it is a document also signed, apparently by Mr. Way, with the date of November 27, 2023, which further says request to appeal by statement of inability to afford payment of court cost or an appeal bond in justice court. Are there other documents on your share screen?
Your Honor, may I clarify something for the court?
I right now, I just want to note for the record what he's showing us, and then we can talk about what it is. But right now, I just trying to clarify, is there anything else that you're showing on your screen, sir?
Yes, that's it. I just wanted to show that one, and then the next thing that I want to get to in the testimony.
Hold on, because Mr. Boyd has a question about those. I just wanted to note what he was showing us, because the appellate record won't capture that since they're not being offered or admitted into evidence. He's just showing it to us. Mr. Boyd, you have a question about what he has shared?
Your Honor, on that third page, the document that titled confidential, that's actually Amanda Cantu's signature. It is a non-contesting the statement of inability to pay. So
I see. Thank you for that clarification. It was hard to read that signature and I couldn't tell it from the others, which is why I said it appears, because I'm not verifying anybody's signature. But thank you for that clarification. All right, Mr. Wape, you may proceed with your testimony.
So now back to the jury demand. As I was filing pro se,
No. We're not going back to that because I've already decided that we're going to proceed, and I can't change what Judge Wong has already done. That is something that you can appeal to the Court of Appeals. You can certainly do that, but that's not the subject of our hearing today. So we're going to move.
It's relevant. I can't mention in my testimony why I request. Basically, what you're saying right now, and if I can continue for 30 seconds, please. What you're telling me right now is that based on the fact that you don't have information or you're going off of their information, I can't tell you my side of the story, is what you're saying.
No, that's not what I'm saying. That's not what I'm saying.
Okay, please clarify.
Let me say what I'm saying. What I'm telling you is that the issue of whether or not you are entitled to a jury has already been decided by a judge. I do not work I'm not an appellate court judge. I'm a trial court judge. And so my decision gets appealed to the Court of Appeals. Judge Wong's decision gets appealed to the Court of Appeals. We're not the boss of each other, so to speak, right? He makes his rulings, and if you don't like his ruling, you got to go to the Court of Appeals. I'll make a ruling. If you don't like my ruling, you can go to the Court of Appeals, but he can't overrule me and I can't overrule him for things that have already been decided. Does that make sense? That doesn't mean that people can't ask they be reconsidered, or that certainly is something that could happen.
I hear you. I just need.
Yeah. So what I'm saying is I'm not reconsidering his ruling. I'm saying that right now, the law of the case is that he has decided that your jury demand was not timely filed. I'm not changing his ruling about that, but that is a ruling that if you don't agree with, you have a right to appeal to the Court of Appeals. Just like when we're finished today and I make a ruling, if either side does not like that ruling, either side has a right to go to the Court of Appeals. Does that make sense?
Yes, ma'am.
Okay. All right. Go ahead.
I would just like to, I have to mention that because it's relevant to the case. You don't need to overrule, but I do need to tell the story as this is being recorded.
Okay,
so
go ahead.
I feel like it's, okay, I just need 2 minutes uninterrupted.
Well, I can't promise that, but I will let you go.
Aaron cannot furnish, the plaintiff cannot furnish a notice of that trial. They didn't notify me.
I'm sorry, I didn't hear you.
Yes,
the plaintiff cannot.
Hold on, counter plaintiff.
Stop. Let me tell you what I heard so you'll know where to start. Here's the last thing I heard was the plaintiff cannot provide a notice.
The plaintiff did not provide and still cannot furnish a notice of that trial date on January 18th, 2024. They never notified me. Now, let me tell you why they never notified me. On January 5th, I went to jail. On January 3rd, I had sent over evidence in this case to build my case. 2-3 days later, they processed a warrant, intercepted an ongoing case as I was trying to prove it, and just literally took me to jail. I'm working like $160,000 job if she wants to talk about character. I get off on a Friday, and then boom, Saturday, Sunday, Monday, I get out. As soon as I get out, Aaron had 0 documents inputted into the system for any discovery of anything. I get out Monday night, it's like 11 or 12 o'clock in the morning, she starts sending me documents. The next thing is like, there's a trial set, and here you go. There was never any notice at all. I get out January 9th, and they have court set January 18th. Now, January 11th, I had already set my, demand for jury. I had did it through the e-file system because they switched it from pro se, and I could just file email, and then they switched it. So I get out of jail, go in January 5th, and get out January 11th. Prior to January 11th, they never had any trial date in there. There was never any information, never any notice or anything. So I get out immediately, notice motion of continuance. I get out immediately, jury trial. I get out, and I had already had that jury trial on file as far as emailing it. So that's literally the reason why we motioned to recuse Judge Todd Wong, because I had stuff on file and they were just ignoring it. They're bypassing it. I literally have Aaron on the record, and I have the email right here of her saying that the respondent email that I've been sending documents to filed in e-source, she never seen it. Before they even set that January 18th trial, I had called Marilyn, her representative in her office, to let them know, hey, there is a demand on file. And then even prior to that,
Your Honor,
I'm not done.
Hang on, Mr. Boy. Mr. Way, I tried to give you some leeway here, but I think I need to get you to focus on the facts that relate to the claims in the case that I am going to decide. I'm not going to decide this issue about the jury trial. That's not going to be
so we can just appeal that then, right?
That's what I was trying to say
Yeah, all right,
earlier.
forget about it. I'll just appeal it because you guys aren't hearing what I'm saying. I just wanted this to be recorded
it's
on
not
file.
that I'm, it's not that
Yeah,
we're.
I just wanted it to be recorded on file when they, sorry.
It's not that I'm not interested in what you have to say and the position you're taking. I am interested, but I am not going to overrule Judge Wong's decision. He's made it, it's done. And if you are not satisfied with that decision, your appeal to the Third Court of Appeals is the place in which you would deal with that issue.
Oh yeah. All right, we'll just do it there.
So my point for today is just to focus on the issues that are before the court today, which are essentially a brand new trial on the eviction with the claims that the plaintiff has brought for non-payment of rent, as well as attorney's fees and other costs, right? That's all I'm here on with regard to the plaintiff's claims. Then your claims, the ones that I have jurisdiction over, which we'll sort out in a minute once I hear some evidence, right? And that's why I'm saying that at this point, we're just in the evidence phase. This is where I get facts, not argument, not legal discussion, just facts. What happened? Who did what? Who paid what? Who said what? Like, who did something? Those are the facts that I'm listening for, so that then after I hear your closing arguments where you will apply fact to law, then I will make a decision, right? So give me the facts. What happened? Why shouldn't you be evicted? What did you pay? What didn't you pay? When did you pay it? That sort of thing. Make sense?
Okay, so I shouldn't be evicted because you don't want me to re-narrate this information, but the reason is the original petition. Past that, it's the next thing I just showed you, the document where I didn't need to pay anything to update until we get to trial here. Now they reset the trial, and to be honest with you, the way that you guys reset the trial, I'm not with it. And let me elaborate on that.
No. The trial was set, the trial was noticed, the trial was assigned to me. We're in the trial.
It's irrelevant. It's irrelevant. I hear you.
No, it's not that it's irrelevant. It's that it's not appropriate for now. That is something that you can complain about if you want to on appeal, but not for today. That's all I'm saying.
Well, I hear you. All I'm using that to tell you. I'm not saying it's not relevant.
I'm saying it's not appropriate because it's beyond the scope of what we're doing today.
I hear you. All I'm saying is, you guys, and I'm looking up the thing from Angela. It's literally a hearing, quote unquote, document. I could share my screen. She told me it's a hearing. So what I'm trying to get at by referencing the demand trial is that this is inappropriate right now. To have a trial when I'm not prepared for it because I've had so many documents, and this is why he's being recused right now. I know it's irrelevant, but I need to mention it since we're on air and we're going in. This is not an appropriate trial because it was designed to be from a jury, is what I'm saying.
I understand that. But we're not going to deal with that today because that is the subject of something you're going to do on appeal. So for one more time, I'm going to ask you, please, to stick to just what is relevant for purposes of our time together today. And that is the eviction issues. Did you pay rent? Did you not pay rent? And so forth. Now, in service of that, let me ask another clarifying question.
And there was a motion to transfer too, sorry.
When you paid or filed, I should say, when you filed the affidavit indicating that you did not have the money to pay the appeal bond or the surety bond, did you understand that document to mean that you did not have to pay your rent also?
Ma'am, can I share my screen?
Yeah, you certainly can, but first answer my question. Did you understand that document to mean that you did not have to pay your rent?
Which document?
Let me start over my question. Listen to my question. When you filed the affidavit that indicated that you could not afford to pay the appeal bond or the surety bond, when you signed that document and filed it, did you also think that document meant you did not have to file or pay your rent? Is that what you thought? That's my question.
That's not what I thought. That's not what I thought. The document said that I did not need to. It's not to estancia villas until the case is processed. It's either to the JP court or it's either to the civil court.
I don't think you understand my question. Let me try again. And maybe you said, maybe you did understand it and maybe I got my answer, but let me clarify. I just want to clarify. When you filed the affidavit indicating that you could not afford to pay the appeal bond or the surety bond, when you filed that document, were you under the impression that that document relieved you of your obligation to pay your rent?
No.
Okay. All right. That's my question. You've answered it. Let's move on. Next part of your testimony related to the facts of the case, not the jury trial demand and all that. I just want to know about the facts of the eviction case. You may proceed with your testimony.
Am I on screen share right now?
Yes.
Okay. So stop screen share. Let's go to this. What does this say right here?
What I see on the screen is some email
from Angela.
It related to a hearing confirmation, yes. But again, Mr. Way, that has to do with the procedural issues related to your request for hearing or trial or juries and so forth, which is not what I'm entertaining today. That is going to be,
but look
if you
below
want to talk about it, the subject of your appeal, should you decide to appeal once the decision has been made, not the subject of what we're doing today. And so I'm going to rule that that's not relevant. We're proceeding and we're in the middle of the trial. So I want to know about the facts of the case. I want to know about the facts of the case. I want to know about your time at estancia, your rent, your claims against the plaintiff. Tell me about those facts, not about setting matters for a hearing. Okay?
No, listen, ma'am, look, it literally, can I read this out loud to you, please?
No, you don't need to read it to me because I can read and I'm looking at the document and I've seen it.
It says as well as the plaintiff notice of rent default for motion to transfer. There's a motion to transfer the case. Please stop acting like
that. I understand
it literally says it right there. It's not just the merits. There's so much.
Mr. Way. Okay, Mr. Way.
Look, there's another one. There's another one. Here, check this out.
Hold on. Are you telling me that you want me to entertain a motion to transfer today? You have yet to say that, but if I'm now understanding you
tried to shut me down consecutively.
Stop. I will add to our agenda a motion to transfer. Now, let me point out that when I was setting out the agenda earlier this morning, and I said, there are the 4 things we're going to talk about today, you did not mention there was also this motion to transfer. Had you done so, I would have been happy to add it to our agenda. I will add it now. So I'm going to add number 5 to our list of things to do today is your motion to transfer.
Your Honor.
Hold on. It's a little late in the game for us to do it, but we will come back to that in a minute. Right now, we are in the middle of your direct examination. Ms. Du Bois is entitled to a cross-examination. I need you to finish your direct examination so we can get to her cross-examination and to any other evidence you have to submit so that we can complete the evidence phase of our trial. So I will add motion to transfer to the document, which, as you point out, includes in the notice the merits of the trial to be discussed today, which is what we're doing, along with all those other things that we've added to our agenda. Now, move on, if you would please, to the next fact. Tell me about your case.
I would like to be 100% respectful with you guys, but I think you're overlooking a lot of these facts. The first thing I want to mention, if I can just get 1 minute to go off, the first thing I want to mention is that you guys were already aware that there was a motion to transfer. Why was that not on the case? I'm not even done with that. All of my documents have been on file. Nobody looked at any of my documents prior to this. I'm trying to tell you about the demand for the jury.
First of all, that is not a correct statement because I did look at your documents before the trial. So I would appreciate you not assuming things about me. I'm not assuming anything about you, and I don't want you to assume anything about me. I appreciate that you have your opinion about these things. I respect that, but I need you to respect my ruling. Here is my ruling. We are in the middle of a trial on the merits. We are hearing at the moment your direct testimony, which is about the facts that relate to what happened in the case. So I need you to focus your attention and your testimony on what happened. Who did what? What did you pay? What didn't you pay? What did they do? What didn't they do?
I hear you.
And when you're done with your testimony, then I'm going to hear argument, at which point you can tell me these other things that aren't testimony. But in the middle of your examination, I just need to hear the facts. Okay, related to the underlying litigation, related to your eviction. That's it.
Mhm.
And then when we're done with that part of the case, I'm happy to hear
Okay.
these other things.
All right. Okay, thank you for clarifying that. Thank you
You
for
bet.
clarifying.
You
So
bet.
pertaining to the case, there is the original petition, and then beyond that, there is the surety that I just showed you. And my impression is that I'm not supposed to pay until we're in trial. Now, as far as everything else, I'm gonna wait to relay that to you. But as far as that goes, that's
Look,
it.
let me clarify. When you say I'm not supposed to pay, that's what I was getting to earlier.
Mhm.
What is it?
Until-
What is it that you think that affidavit of inability to pay absolves you of the responsibility to pay?
Thank you. It absolves.
What do you think that you don't have to pay?
Since they sued me for right of possession only, that 1,356 was actually supposed to go to the JP courts on a monthly basis while we're going to court, is what I'm saying, right?
Okay.
To the JP court is what I'm, not to the Estancia Villas, but to the JP courts. What they done after I had to speak with them is they corrected that document, right? Which actually let me go with $0 and 0 cents up till now. So what my ultimate argument is, the original petition, as if I didn't do anything wrong on it, if you look and you read the original petition in conjunction with the document of appeal and the surety. Like, I'm not paying to the JP court because they sued for right of possession only, and I'm also not paying to the Travis County court because they sued for right of possession only. Here we are on, what is this date? February 29th, and we're going to trial. So I'm gonna hold off on how the dynamics of how the trial was set up and how I was set up and all the other stuff, because it seems like that's the only information you guys need right now.
Right now, I'm just trying to get the merits of the case figured out. And your answer to my question about what you thought you had to pay or didn't pay is super helpful. So thank you for that. Are there other facts that you can give me in your direct examination at this time before Ms. Du Bois begins her cross-examination? Anything else you want to tell me about your claims against them, their claims against you, as it relates to the pleadings on file? That's all I'm asking for right now.
Yeah, other than my countersuit and my demand, I just need to give.
Tell me about that as well. This is your opportunity to tell me about the claims.
So the countersuit, I've met Jennifer Alvarado's children, and they seem very. They're raping children around here.
Your
There's
Honor?
an entire.
Okay, so hang on a second. So
Yes.
If there is a criminal allegation, I do not have jurisdiction over criminal cases, and this one is not involved in a criminal case. There's no notice to the family and so forth. So I'm not going to entertain any
criminal.
Right, because I don't have authority to do that. That's not up to me, right? And it's not part of your eviction case. So I won't entertain any of those claims that relate to criminal activity, and you have several of them in your list.
30 something.
I can't do that before you. I can't provide that relief. Now, that's
I'm not worried.
Without prejudice to you going to the appropriate authorities related to your criminal allegations. That's between you and the police and the DA and so forth. You can do it in another forum. You just can't do it here. So all of the causes of action that you spelled out earlier that relate to criminal cases or criminal investigations, we will not deal with those today. And any request that you've made in connection with something criminal will be denied here, because I simply
I'm not worried about that.
Okay.
That was the initial countersuit, and it's in conjunction because it's relative because it's my residence and the players involved.
I understand why it's important. Yeah, I get why it's important to you. That makes total sense. I just wanted to be clear. I do not have the authority to rule on those. So all of those requests will be denied. And while we're on the subject, I couldn't, even if I wanted to, grant relief in the $200 million range, because
I think it's 10 million here. Well,
it exceeds the jurisdictional limit of the county court at law, and I'm sitting as a county court judge at the moment, so I can't do that either. So what I'm asking you to do is just to finish up your testimony. If there's anything else you want to tell me related to the eviction case, because that's all the authority I have at the moment.
Yes, and that's why there's a motion to escalate the case, because this is not a civil case. It is a civil case, but there's also a countersuit, and that's why there's literally a motion to escalate to a higher court, a district court, or a federal court. To be honest, I actually said federal court.
You can file those cases in the appropriate courts if you like. That's up to you. We won't be dealing with that in this case. So all of your requests related to those will be denied. But
there's a motion to escalate, though.
You can, well, I'm not familiar with such a concept. If you have if you have a criminal case, you go talk to the criminal people. If you have a federal court case, you go talk to the folks in the federal courts, right? So my point is, I am only dealing with this eviction and the related issues to the eviction, and I want you to finish up your testimony because I want to hear all that you have to tell me related to the eviction case, and that's it. Okay, so finish up your testimony on that, and then we'll proceed.
Yeah, we can proceed. Let's see what else is there. Let me check my notes here.
Yeah, take your time.
Did I mention the date of trial set and how she wasn't able to furnish any?
You did.
Okay, yeah, that's it. They've got all my. It's cut and dry. The document and then the conjunction of it with the other document. Here we are.
All right.
And then the rest of it I can tell you about.
If you're done with your testimony on the facts related to the eviction, then I'll let Ms. Du Bois ask any questions if she has any for you. All right. Ms. Du Bois, your opportunity for cross-examination begins now.
I have no questions for Mr. Way.
Okay, so she doesn't have any questions for you. And I think I've asked you for the clarification of the things that I wanted to ask about in terms of the payments and all that. So I think I don't have any other questions either. Is there anything else related to the eviction case, Mr. Way, that you want to offer at this time?
Can I talk about the stuff that I wanted to talk about, or are we waiting for another time?
Is it related to the eviction?
It is related to the eviction, but you just told me not to talk about it.
No, I'm telling you now is your chance to talk about the facts related to the eviction issues. Did you pay your rent? Did you owe rent? Did you not owe rent? Were you required to post a bond? Did you post the bond? Did you pay into the court?
Perfect. Yeah, let me just summarize. It's 30 seconds of a summary.
Let me finish, please. Those are the facts that I want to hear about related to the eviction. The motion related to the setting of the hearing, or whatever your complaint is about that, the jury demand, those are not things that I'm interested in hearing about right now. We can talk about that later. Right now, I'm only interested in the facts related to the specific issues around the eviction. So anything else about that?
Yeah, it's a fact that I proceeded with the legal proceeding, or I was conducting the legal proceeding accurately. It's a fact. It's a fact that I interpreted the information from the original petition correctly. It's also a fact that I had clarification from the JP courts, or when we escalated. So I have these documents to protect me as far as those go. Everything else, I guess I can't talk about until you're ready for me to talk about.
I want you to talk about anything else related to payment of rent. Like if you made a payment, I want to know about it. If you didn't make a payment, I want to know about that. I want to know about anything related to the eviction case before we move to the next thing.
Yeah, that's it. I have my documents on file.
All right. Anything else, Mr. Boyd?
Your Honor, I have no questions for Mr. Way.
All right, that will conclude the evidence phase of our trial on the eviction. We will now move to
I can't even hear you.
Yeah, I think the judge is frozen. Hang on just a second.
Okay, thank you.
Yeah, because I see everybody else moving except for her.
Man. But hidden appeal, and then I send this to New Western District. Screen browsing, live screen browsing Zoom stopped due to an Oh, can you still hear me?
Mr. Way, we can still hear you. We need to get our connection. Yes, I can still hear you.
Awesome.
Hello?
All right,
All
Judge, where you left off at before you froze, you were saying this will conclude the evidence phase of our trial. On the eviction, we will now move to, and then you froze.
Okay. All right. Closing arguments is what I was saying. So now we're going to essentially closing arguments, Mr. Way. It's just an opportunity to summarize the facts and apply those facts to any legal arguments, right? Like state the statutes that might apply, or legal theories or cases that relate to the arguments for why I should grant or should not grant the relief that's been requested. And once we finish with both sides closing arguments, we're going to take up these other issues that you want to talk about to the extent that they're relevant for us to do so today, particularly the motion to transfer and whatever else. So we'll get to that in a minute. Right now, closing arguments on the eviction itself. Ms. Du Bois will begin, and then we'll hear from Mr. Way. And because she's the plaintiff, Mr. Bois gets to wrap up. Go ahead, ma'am.
Your Honor, the evidence in this case shows that Mr. Way.
Oh, wait, I'm sorry. One thing, let me just clarify. Mr. Way, since you indicated that you don't have anything else, I just want the record to reflect correctly that you have rested your case subject to your arguments on the other motions before the court, like the transfer and so forth. Is that correct? You rest your case at this time?
Yes.
All right. Okay, go ahead for closing arguments, Mr. Boy.
Your Honor, the evidence in this case shows that my client has a superior right to possession. There's a lease contract between Mr. Way and Estancia Villas that has been offered into evidence. There's evidence that Mr. Way failed to pay rent beginning September 1 of 2023, which is a default of lease. That default of lease allows my client to possession of the premises. In eviction suits, that is the sole issue for the court to adjudicate. There are no counterclaims. Mr. Way failed to pay rent, and so my client is entitled to possession of the property. They're also entitled to the back due rent that is owed to them. And the evidence showed today, Your Honor, that because he has not paid for each of those months, Mr. Way is liable to my client for $8,136. Your Honor, the contract between the parties.
So let me stop you there, only because I just will need to clarify whether or not you have any rebuttal evidence to Mr. Way's testimony. You didn't tell me that you did, so I moved right to closing arguments. But now you're making an argument that he owes X dollars, the $8,000 sum, for example, as opposed to some other number, because his testimony was that some amount of money, roughly $4,000, was paid on his behalf. So you didn't ask for any opportunity for rebuttal evidence, but I want to make sure that you've got that opportunity should you need it before we wrap it up. Or are you simply relying on the evidence in the record, given the pay record?
Yes, Your Honor, I'm relying on the evidence of both my client's representative and the records and the exhibits that we've offered.
I just want to make sure that everybody has every opportunity they're entitled to. So, all right, with that, then, Mr. Way, what she's saying is she does not want the opportunity to add any rebuttal testimony to what you testified to. So what I have in the record is what I've received so far in terms of the testimony from the three witnesses, as well as the documents that were introduced and admitted into evidence. And with that, you may proceed with your closing argument, ma'am.
My closing arguments are
her. She was wrapping up.
Oh, sorry. I apologize.
I said, ma'am. Sorry. Go ahead, Mr. Boyd.
I didn't even hear you.
That's okay. Go ahead.
Your Honor, the contract dictates that my client is entitled to an award of attorney's fees here, and we've properly presented evidence as to my client's entitlement to $2,600 in attorney's fees. Your Honor, my clients testified that Mr. Way has failed to pay rent. Mr. Way is the person responsible for rent under the lease contract. There's evidence presented to the court, that testimonial evidence that he failed to pay rent, any rent, except for $720 at the beginning of his tenancy. And this is also proven by Plaintiff's Exhibit 5, which was the ledger showing that Mr. Way only paid $720 when he moved in. No other entity has paid, no other payments have been applied to Mr. Way's account with my client. And so, Your Honor, this is a simple non-payment of rent case. There's additional reasons for which Mr. Way has defaulted under his lease that my client has provided as well. which is the conduct-based violations that was pled. There's evidence on file to show that Mr. Way was arrested for a criminal harassment charge that is a breach of the contract and therefore a default under paragraph 23.1B. And so again,
let me ask you about that. Hold on, let me ask you about that. Does your lease agreement indicate that anybody that is even arrested, even if they've not been convicted of something, is a violation?
That's correct, Your Honor. Criminal conduct under paragraph 11.1A.
Well, it's not criminal unless you've been convicted of it, right?
Your Honor, he's been charged with a criminal offense of harassment.
But that doesn't mean he's guilty of it, right? I mean, people get arrested all the time and then they go to trial and they're acquitted. That doesn't mean that they've, in fact, that means the opposite of criminal activity. It means they've been acquitted of what they were accused of. So I'm just trying to understand if your contract with Mr. Way says that he has to have actually committed criminal conduct or simply that he's been accused of it.
Your Honor, the lease contracts prohibits a tenant from engaging in criminal conduct. And then under the default of lease provision, it provides that it is a default of the lease for you or any guests or occupants to violate the lease, criminal or other laws, regardless of whether or where arrest or conviction occurs. In addition, Your Honor, 11.1B prohibits engaging in disruptive, harmful, loud or obnoxious behavior. My client testified concerning that conduct, as well as threatening conduct against others, including staff. That was 11.1C. My client testified concerning threatening conduct.
Objection. Hearsay. Where's your evidence? Where's your evidence of it?
Mr. Way, hang on. I'll overrule your objection because we're not in the evidence phase. She's not offering evidence at this time. She's just summarizing what she believes the evidence has shown, not giving evidence. So that's the difference. Go ahead.
Ms. Cantu also testified about Mr. Way's conduct at the property prohibiting or affecting their business operations, which is a violation of 11.1D. And so for these reasons, these violations of the lease are a default under paragraph 23.1B and is another basis for my client to seek possession and terminate Mr. Way's right of occupancy of the premises. So at this time, Your Honor, it is my client has the superior right to possession based on the contract, and they are seeking the amount of back due rent and attorney's fees, and we'd ask that the court enter the judgment that we have proposed.
All right, thank you. Let me ask another point of clarification. You've indicated the back due amount that you seek, which if I understood your calculations correctly, were calculated by multiplying 1356, which is the amount of the monthly rent, times 6 months. Was that correct?
Correct, Your Honor.
But I didn't understand, and if I understood your calculation earlier, you calculate that number to be $8,136, correct? I didn't check your math. I'm asking about that now, and just so you can know where I'm headed with this. If that's the calculation, I don't see where you have given Mr. Way credit for the $720 you all admit he paid. And so would it not be—
Your Honor, this is just for the non-payment of rent. In eviction cases, we can only seek a judgment on the non-payment of rent. And so the $720 that he paid at the beginning of his tenancy would have been for prorated rent for the month of August.
Objection.
I see. So you're not
Objection.
asking for— hang on, Mr. Way, I promise you're going to get your turn. I'm just asking her to clarify what she's asking me to do, and I'm trying to check her math. So let me get clear with her about what she's asking for, and then you can give me your closing argument. So that I'm clear, the $720 that he paid, that you all admit that he paid, was applied to not applied to September, October, November, December, January, or February, because it was not due for those months. It was due and paid prior to September of 2023. That the position you're taking?
Yes, Your Honor, and that is evidenced by Plaintiff's Exhibit 5.
All right. I just wanted to clarify all of that so that Mr. Way understands what happened to that 720 and whether or not it was credited or not credited. And I want to understand that so that I am clear about what you're asking me to provide you a judgment for. Okay, thank you. Anything else?
No, Your Honor.
All right, very good. Thank you. Mr. Way, it is now your opportunity to give me your closing arguments, and you may begin your closing argument at this time.
Yes, so I moved into Estancia Villas August 21st, and I had paid the $720, fell on some hard times, and there was a delay in payment on my behalf. UDR, a $15 billion corporation, proceeded to collect the asset of Estancia Villas or Steadfast Management. They changed everything up. So September 15th, I couldn't even pay rent. Nobody in the 341 buildings here could pay rent until around September 15th. On the 25th of September, Jennifer Mercado showed up and gave me a notice to vacate. Keep in mind that I had moved in with rent paid, $720 advance deposit and everything for September, for the 1st of September. So between the 1st of September and the 15th, I wasn't even allowed to pay. And then 7 days, or not even 7 days, 10 days after that, she shows up with a notice to vacate. I didn't even get 1 month to do anything. It was just a notice to vacate. In addition to that, I made multiple attempts that I do have on record and on file to pay a portion, even being 80%
Your Honor,
of the
I'm
rent.
going to object just because there's no facts into evidence or testimony in
It doesn't matter.
ways.
I'm going to overrule the objection.
Yeah, I'm just telling the story. I'm summarizing.
Yeah, but Mr. Way, let me just point out, technically she is correct in that your argument must relate only to those things that were produced in evidence already. And what she's arguing is this is new information. I'm just going to ask you to tell your story based on what we've already discussed. I don't want you to.
Okay, I hear you. Well,
all right, go ahead.
Yeah, I got you. There's a book on file as far as the e-files go and all of my motions and documents. Everyone's been overlooking. This has been going on since December. This is the whole reason why everything's becoming complicated now. There was just literally an eviction appeal. It went to another plaintiff petition for JP courts, and now there's like 10 involved. You have been assigned to be the judge on all cases in the with respect to Travis County at law. So essentially, it's like a cluster. I don't want to use the word here, but basically what I'm trying to get at is that all of my documents, including what I just mentioned, was on file. The judge could have seen it, Aaron could have seen it. And when I say that, I have literally written a book on this, what my experience has been. And it includes me showing up on August 21st and then not having the ability to pay rent until the 15th, and then getting a notice to vacate on the 25th. And then after that, having a month before trial, and then it being paid on my behalf because they've been monitoring me inside here this whole time. And then boom, the original petition in conjunction with my appeal. And that's why we're here right now. And just to further reiterate, there's a demand for a jury trial on here. I know that now is the appropriate time to talk about it. So as pro se, I was able to file that electronically through email. That should suffice as far as me requesting, because I had 4 subpoenas literally delivered by the constable through the same channel. So it doesn't make any sense for my demand to not be on there. In addition to that, when I came out of jail, this is the main thing right here. Judges, I know you can't overrule it, but I'm mentioning it because it's a fact. Like the trial that's being handled right now, it's inappropriate. For one, Angela told us that this is going to be a hearing. So I'm not
Mr.
prepared
Ray,
because I was under the impression.
But hang on that point, if you look carefully at what you received from Ms. Burks, which you shared with us on your screen, there's
another one prior to that. I hear you.
What you shared on your screen, which you asked me to read, which I did, indicates very clearly that in addition to your motion to transfer and other matters, today you should be prepared for a hearing on the merits. That's spelled out in the notice that you received. I just want you to
with the jury trial. With the jury is what I was talking about. I'm sorry. That's what I meant.
You meant that it was a hearing, and I was reacting to your point about it's a hearing and not a trial. I just wanted to point out that the notice that you shared with us this morning very clearly indicates it's going to be a hearing on the merits, meaning a final trial on all the matters related to the eviction case. I just wanted to point that out. Go ahead.
Okay. Yeah, so there's supposed to be a demand. It's supposed to be a demand trial. And what I'm trying to get at is that the fact that like they've been doing a lot of sneaky stuff. So Aaron mentions, well, this dude, he broke the lease. He violated the lease by committing a criminal act. First of all, I haven't even been proven guilty. I have a whole lawyer and they're about to dismiss the case, to be honest with you. I'm just saying. Independent of that, I have information relative to the case. Hold on. I don't even know how to put this.
Well, let me stop you by saying, as long as it relates to the eviction case, if it's about some criminal conspiracy or something else.
That's what I'm trying to stay away from. Yeah.
Yeah, stay away from that. Just give me your closing argument on the eviction case.
I'm just trying to get at the trial wasn't set appropriately because had I gotten out of jail, Aaron still cannot furnish any notice like, hey, we're letting you know that there's a trial. As soon as I get out, they're just like, hey, there's a trial. And then they reset the trial and I let them know that there's also a demand. At the point where they reset the trial, they should have also considered my demand for, so the 17th, due to weather, inclement weather and pipes bursting, for one, they couldn't even provide notice to me, the defendant, that there was a trial in state and I had just gotten out of jail. There was no fair warning or anything like that. They're just like, hey, there was an act of God. Literally, the trial is reset. Now they're already aware of my demand for the trial and they just reset it. Here we are. They reset, they had the opportunity. And I've told everyone, not just you, Aaron, Colton, everybody, there's a roster of people that have been stressing out, sending emails, linking emails, e-filing for this demand trial. On the 18th, not only did they not provide anything prior to that, as far as setting that trial, but then they also, in conjunction, the same violation that I went to jail for, Aaron and all of the representatives here decided to imitate and mimic that with Travis County Sheriff's Office, and then literally got declined. So I went to jail for harassment, trying to plead my case. I get out, they file another harassment charge on me and then get declined on it and then literally try to spin the argument and then without any notice, try to set trial. Then they reset trial and then they say hearing and I have a demand trial since the 11th. And not only did I file this thing on the 11th, but Travis County's website says within 48 hours, they're gonna process. So they actually accepted it on the 16th of January, 2024. They let 3 days extra elapse. What I'm saying is I've been on top of it as far as submitting my documents in the proper way. And basically they've just been overlooking it and trying to do other tactics in conjunction with different departments to minimize me and prevent me from speaking. There's a lot going on here. Now, in regards to the other, if I can share my screen with you again. Here it is right here. It says Judge Livingston has been assigned. Can I share my screen?
Yes.
Okay. Share screen. Start broadcast. Okay. So it's a little blurry, but the state of Texas, they basically assigned you to all the other cases. It's almost as because the cases piggyback off each other.
Okay, so Mr. Ray, hold on. We're going to deal with other cases another time.
Sorry, I didn't know this was the time.
No, that's all right. We're going to deal with those at the end of the hearing because we can clarify what happens in those cases. As I understand that order, it only mentions this one cause number, but we'll clarify that later. Right now, again, I just want you to stay focused on the eviction case.
Okay. So yeah, here goes their notice. There goes Jennifer, aka her name's technically Amanda. I'm telling you, she told me, it's not even relevant at this point. It is kind of, but she shows up with a notice, and here it goes, right here. Can you guys explain this right here? There's literally nothing that I've done, making inappropriate or derogatory remarks. They don't have any evidence of anything. That's what I'm saying. So they're just trying to do character assassination at this point in time. Not only did they swindle the system and do all kinds of stuff, get trials set without any notice or anything to me while I was in jail and I was providing documents, they also can't provide where and when I did any of this stuff right here, especially considering the initial petition, how it didn't have any lease violations on it. And then fast forward to this time right here, December 6th, there's literally like, what have I done? And can you please elaborate and explain and document it and put it on camera, please? Because you can't just say that. It's character assassination.
Mr. Well, hold on. When she makes an objection, you need to stop. But before
I didn't hear it. I'm sorry.
That's all right. Don't worry about it. I need you to focus just on the eviction. And you don't get to ask any questions of her at this moment. So move on.
Okay. Yeah. And so just in summary, basically, it's just a mistrial. It's a mistrial from the very beginning when they processed it without any legitimate cause to evict me. And that's what the appeal was for. I was in a position, things were paid on my behalf. It's literally a document. And the document isn't even 100% accurate because they forgot to add that $720, unless it's just for unpaid rent, in which case they still put the $4,068 as claimed rent as of that time. There is no pursuit for unpaid rent, and there is no pursuit for applicable attorney fees. In addition to that, the document that I have for surety approved by JP3 and escalated to Travis County and also signed off by Estancia Villas at that time, it basically minimized my $1,356 rent payment to $0 to the JP court at the time of court, in which case I actually demanded a jury, so we shouldn't even be here in the first place, is my argument. And that's it.
All right,
right now.
Thank you.
Yes,
Ms. Du Bois, anything further? Mr. Way, if you don't mind stopping your screen share, we'll hear from
How do you do
Mr.
that?
Boy. Just hit that red stop share button. Thank you. Go ahead, Mr. Boy. Anything else?
Your Honor, again, the facts and the evidence presented to you today show that my client has a superior right to possession. Mr. Way has now argued that he was not provided notice. In the court's file is a file marked copy of a notice of hearing and trial for January 17 that was served on Mr. Way on the email address that he provided to the court in his statement of inability to pay. There's simply no defenses that Mr. Way raises that do not entitle my client to possession of the property, as well as the amount of rent that he has failed to pay. And so we'd ask that the court enter judgment in plaintiff's favor.
Thank you. Just another point of clarification, Mr. Boyd. Do you have handy, and maybe you could share your screen, a copy of your pleadings in the county court filings so that Mr. Way can see what you spelled out in terms of your request for unpaid rent, attorney's fees, and other matters? There seems to be some confusion, and maybe the confusion's on my part, perhaps, and maybe everybody else is clear, but I think it appears to me that there may be some confusion about what your client requested in justice court versus what you've requested in the trial de novo. And so I just wanted to be clear so that I'm clear, because it's my understanding that when you get to the county court and you file pleadings on file in this trial de novo, this new trial in the county court at law, at that point, your pleadings can ask for any number of things that may or may not have been part of the prior proceeding in justice court. And so I think there may be some confusion about that. And I thought it might be helpful if we just kind of scroll through that petition. And so if you'll just slowly scroll down to the requested relief and the allegations regarding unpaid rent. So let's stop there. So we can see now on page 2 of the plaintiff's petition in county court, there are allegations of a breach of contract of the lease agreement for the non-payment of rent and other sums of money. And if you'll scroll down further on that same page, there's also an allegation of breach of contract for other prohibited and criminal conduct, which we've discussed. And if you'll scroll down further, you'll see in the county court filings by the petitioner, they describe what they believe are violations of the lease. Keep going down if you would, please. And then there's also a request for attorney's fees. Keep going. And then at the end there on page 3 of the petition filed by the plaintiff in the county court petition, there is also a request for judgment that asks for forcible detainer, immediate possession, and so forth. And then if you'll keep down now to page 4 there's a requested relief that asks for essentially everything they've spelled out. So you can stop your share now. I just wanted some clarification so that we're all clear that what the plaintiff requested in the JP court may be, can be, and apparently is different from what they asked for here. Sometimes that's because landlords are interested in just getting their property back so they can rent it to somebody else. And they're willing at that point to just forego the rent because what they really want is to be able to rent it to somebody new. They cut their losses, if you will. That's sometimes why.
What I'm saying is that
not done. I'm not done.
Oh, sorry. Sorry. Go ahead.
And so sometimes that's what's done. I don't know if that's what their thinking was here or not. I don't have any evidence about that. I'm not making any decisions about them. Simply pointing out that that explains sometimes why what we see in justice court might be different from what we see in the county court proceedings. Here, it's very clear that in the county court proceedings, the plaintiff's petition does in fact ask in writing in their petition for everything they've asked for here today. So there seemed to be some confusion about all that, and I just wanted to clarify that. Second thing I want to clarify is that the affidavit of inability, and again, I don't know what people were thinking or what was in their understanding, and I'm not making any decisions about that because there's no evidence to me about that, and it's not something I have to decide necessarily. But I would point out that often there is confusion by folks about the affidavit that indicates that you don't have the ability to pay the appeal bond or the surety bond. As I understand the law, that does not absolve you of an obligation to pay your rent into the registry of the appropriate court. It has effect related to your inability to pay the appeal bond or the surety bond. Those are really two completely separate and different. Mr. Way, it's my turn. Two completely in separate things. So I realize that here, lots of things going on and people have different understandings about all of that. The way to resolve that, if you are unhappy with the decision, like in the JP court, somebody was not happy with that decision, you appeal that to the county court. The county court makes a decision. If you are not happy with that, you get to go to the next level court, the Court of Appeals.
Perfect, yeah.
And then beyond that to the Texas Supreme Court. So there are checks and balances, and there are opportunities for either party to go to the next level, if you will, if you're not happy or satisfied, or you think that there was a legal error in the court you're in, you have the opportunity to have that reviewed by a higher court. And so I know I said that earlier, and I think it bears repeating just because I want to be clear that everybody has multiple opportunities to have their day in court and get their issues heard and resolved. And that's true for the decision on the merits. That's also true for these preliminary rulings like the motion on the jury trial and so forth. So there is and will be ample opportunities to flesh all that out in the appropriate forums. Now, before we get a ruling and we wrap up for our time today, we still have a couple of other things to talk about. Mr. Way, tell me if you would, what your motion to transfer is about. Once you've done that very briefly, then I will hear from Ms. DuBois about why she thinks it either should not be granted or is not timely. I do have a concern because I believe that those motions, depending on the nature of the motion and what you're seeking, is something that might have been dealt with prior or should have been dealt with before today. I don't know. Tell me what it is you're requesting in your motion to transfer.
Yeah, the motion to transfer is strictly based on biased decisions made by Travis County at Law 1. That's what I need to get out of Travis County at Law 1 because you guys have been taking advantage of me seriously. For one, wait, hold on. I just want to know the nature of the motion, not all the details why you think that motion should be granted. I'm not asking that question at the moment. First, I'm just asking, what is it that you want in your motion to transfer? First of all, I wanted this to be a actual hearing, actual trial, not a hearing. And I wouldn't have done it online because I wanted to do it in person. So the reason to transfer the case was because they put an order of constraint that was vague, that wasn't specified.
You want to transfer what to what is my question. What do you want to transfer?
I want to transfer this case to another county. And I also there's another motion to escalate higher. So there's a motion to escalate higher, and there's also a motion to transfer out of Travis County because they've been biased. And I've also reported that judge to the State Commission on Judicial Conduct. I've reported him already.
Okay,
on top of that, he's recused himself.
Hold on. So that's what I was asking. What is it that you want to transfer from what to what? Because
I want to transfer this case.
Right.
This case wasn't even supposed to be conducted here because it's biased.
Okay. I just want to clarify what the motion is about. And just so I'm clear, I'm going to repeat back what I understand you're saying. You wanted this cause number, this CV 005479 case to be transferred out of Travis County to
Exactly.
some other county in Texas.
Exactly.
Okay. All right. That motion is denied. I don't need to hear argument about that because I do not have the authority to do that. We have jurisdictional rules, venue rules, and compulsory venue provisions and mandatory provisions related to where a case must be brought. And it's very clear that a Travis County property and a Travis County eviction must be brought in Travis County. So I don't have the authority to do that. However, as I've said, if that decision that I've now made denying your motion to transfer out of Travis County to some other county is a decision that you're not happy with, that again is something that you can take to the Court of Appeals. But for today, I simply don't have that authority. So I'm going to deny that motion to transfer.
Your Honor, for purposes of the record, I just want to also point out that Mr. Way filed the motion to transfer venue on February 2, and pursuant to Texas Rule of Civil Procedure 257, due to his allegations of bias, he would have had to have signed that by affidavit, as well as have at least 3 credible persons in Travis County attach affidavits to that, and he failed to do so.
All right. That motion is denied. So I can't deal with that. Now, there are another matter related to some other cases that you have pending in Travis County. Is that right, Mr. Way? Okay.
Yes, ma'am.
So let me just, here's what I want to say about that. I am aware only of this cause number related to the eviction with Estancia today. What I would ask you to do is first confer with whoever is on the other side of that case, whoever's representing who you're suing, or if they're representing themselves, email or call or coordinate with those folks and with Angela Burks to clarify 2 things. One, what's the cause number? Or a couple of things. One is what's the cause number? 2, when are you all ready for a hearing or a trial or whatever proceeding you need me to preside over? When are you going to be ready to do that? And then send in to Ms. Burks, Angela Burks, whatever matters you need me to hear. So if it's a trial on the merits, fine. If it's a trial, then I can have access to the pleadings and so forth. If it's a hearing on a preliminary motion, for example, fine. Just let me know. She will let me know, but I need you to confer with whoever's on the other side of that case so that it's clear what other pieces of litigation are pending that you need me to hear. And then I will clarify my assignment with the regional presiding judge about whether or not I'm needed and assigned to those other cases. But the first step is for you to communicate with whoever's on the other side of those cases to figure out, are we ready? What are we going to hear? What do we need the judge to do? And when can we be ready for those things to be heard so that a hearing or a trial or whatever can be scheduled on those matters at a time that's convenient to my schedule and to your schedule and to the opposing counsel's schedule. So that's the first thing that you can do. And when you've communicated that to Ms. Burks, she'll let me know that so that I can then work with her on a scheduling issue so that we can all be here and available on the same time. And we can do that either in person or on a remote hearing. Either one is fine with me, as long as it's a convenient date and time for everyone that's involved. So that's what I wanted to say about those other matters that are pending. The final thing I want to say about these sort of other matters is Mr. Way mentioned that he wanted to have something happen in person. I just want to point out that I was told that a remote hearing was requested. I don't know if that's accurate.
Hearing. Not the trial.
We use the terms trial and hearing interchangeably, particularly when we say on the merits. That means the whole shebang to us. So I appreciate that that might not be precise and that might be confusing. I get that. But when you are told in a note or a notice that the merits are going to be decided, that is a final matter, right?
Okay, then I had objected to that.
The trial.
To the case.
I'm not arguing about it. I'm just telling you what I was told. That's all. My point here is in offering clarification and explanation for what I'm doing and why I'm doing it, because that is the information I was provided. I'm not saying it was accurate. I'm not saying it was correct. I'm just telling you that's what I was told. So
I
I
hear
was
you.
told we were doing a hearing on the merits. I was also told that the parties agreed to a remote proceeding, and that's why we conducted it remotely. I was perfectly happy to show up in person, but I was told that the request for a remote hearing, and so that's why we're having this hearing in a remote venue. All right. So that's the information I have regarding all of the other matters. I don't believe there are any other sort of other matters other than the merits of the case. And
There
if
is
there
one.
are, what's that?
It's that considering the original petition, there should have never been an eviction to begin with. We shouldn't have even been here. So anything after that point, now you're asking for all types of stuff, is nonsense because there was zero cause in the first place. You can't even be here, is what I'm saying.
I understand that that's the position that you take, and that's one of the reasons why I wanted Ms. Du Bois to show us her petition so that you could be clear and we could all be clear that when you get to a trial de novo and travel in the county court, which is where you are now in the county court at law, you get a trial de novo, meaning a brand new trial with brand new pleadings, a brand new request, and brand new allegations, even perhaps.
Well, having said that, they didn't subtract it.
Stop. Let me finish, please. So that's one of the reasons why I wanted to go through that process of going through the pleadings, because everything in that pleading is before the court. I understand the position that you're taking about feeling like you hadn't done anything wrong, feeling that, you know, people had it in for you. I understand all that you've testified about that, and I'm taking that into consideration. I'm simply pointing out that all of the issues are before me at the moment, and I'm going to make a decision about that. And I want to just clarify, there's nothing else other than the merits of the eviction case now that has to be decided. Is that right?
Your Honor, except for our motion under 510.9C.
Well, that includes one of the requests you're already asking for, which is immediate possession. That's redundant to what you're already asking for in the case. So I think we'll get that.
Okay.
It'll be subsumed.
Well, you guys are certainly getting appealed.
Just know
that.
Stop, Mr. Way. Hang on. She's trying to clarify something. Excuse me. She's trying to clarify something. I just want to be clear about what she's asking me for. I appreciate that there are different avenues to the same location, but I'm going to deal with all that you've asked for and cover all the requests as it relates to the substance of the eviction. Is there anything other than immediate possession, rent, attorney's fees, and the criminal conduct?
Demand.
Is there anything else? Excuse me. Is there? Oh, please, you both have to wait until I'm finished because A, it's just rude, and two, Miss Duet can't take it down when we're all talking at the same time. Let me finish, please. I'm simply asking if there's anything else other than related to possession and rent and so forth and all that. Is there anything else that we've not dealt with that is supported by a pleading on file in this case? Yes or no?
Your Honor, I just simply want to clarify that plaintiff is requesting the judgment be signed as well as the order for immediate possession. That is all.
I understand that. I think that relates to the substance of the eviction. That's going to get dealt with. Is there anything else?
For sure.
Is there anything else, Mr. Boyd?
No, Your Honor.
Is there anything else, Mr. Way?
Let me ponder for a second.
Okay.
To the merits of the eviction without anything else? Yeah, without anything else, nah.
Okay. All right. Then
Just the original petition.
Sorry?
Just the original petition and where we are now with respect to where we are now.
You've made that argument. I understand that.
They need to dismiss the case, to be honest, and restart and sue me for rent is what needs to happen.
I understand your position about that. I get that. I understand. You've made that real clear. I understand that. I think Mr. Boyd has made her client's position very clear. I get that. I am now going to rule on that because I think we have dealt with everything else. Make sense? Okay. All right. Here we go. First, the plaintiff's request is granted in part and denied in part. The part of the plaintiff's request that is denied is a judgment and eviction based on this allegation of criminal conduct. I simply think there is insufficient evidence. Mr. Way, I need you to mute your microphone because you're editorializing and I can't have that interruption, please. Just mute your microphone if you would until it's your turn. Okay. So the part of the request by the plaintiff based on criminal conduct is, I believe, insufficient evidence to prove that. And so that request is denied. the part of the plaintiff's request that is granted is in all other respects. I do not find credible evidence that rent was paid when it was due. There is ample evidence that Mr. Way paid only $720 in the month of August of 2023, and that he has not paid a penny since then, even though the lease agreement requires that he pay $1,356 per month. Those payments were due on the first of the months of September, October, November, and December 2023, and January and February 1, respectively, 2024. And there is no evidence whatsoever that he paid any of those sums. I believe that Mr. Way thought that he was not required to do so. I don't believe that he is correct about that. And so I do find that he owes the sum of $8,136 for 6 months of rent at $1,356 per month, for a total of $8,136. He's not paid that sum. He owes that sum. And so his until judgment in favor of the plaintiff is granted in that amount. There is some testimony by Mr. Way that some roughly $4,000 or so, $4,068, was paid on his behalf by the representatives of this big corporation that owns the apartment complex. I do not find that evidence to be credible. And so I don't think that that the managers who are employed there seems unlikely to me that they would be paying rent on a tenant's behalf to the tune of $4,000. I simply just don't find that credible. And so I'm not going to give that any weight. Mr. Way moved in. He hasn't paid the rent from September to now. He owes it. Judgment is granted for the plaintiff in that amount. There was a request for court cost. I'm going to deny the plaintiff's request that Mr. Way pay those. I'll order that each party pay their own court cost, if any. And so if you have court costs, you pay your own court costs. There was also a request for interest, sort of in general, on the sum that I've now ordered the judgment for in the $8,000 amount. I will not order any pre-judgment interest. I will order post-judgment interest until that sum is owed is paid in the amount of 6% per annum. There was a request for attorney's fees since the plaintiff has prevailed on their claims, at least prevailed in part on the request for the eviction to the tune, or to the on the ultimate issue regarding the non-payment of rent. So I do find that $2,600 in attorney's fees for all that's been done throughout the case is a reasonable and necessary fee, and will order attorney's fees. Those attorney's fees will be due and payable on or before April 1, 2024. That way I'll give Mr. Way some opportunity to pay that. He's indicated that he has a sufficient income. He indicated his income was in the $160,000 range. And so despite the affidavit of inability to pay the appeal bond, he's testified today that he has income sufficient to pay the attorney's fees. And so that sum will be due by on or before April 1, 2020.
I object.
That's okay. You can object, but right now you got to pause your thoughts.
Sorry.
Your
I never said that. I just want to clarify. Gotcha.
Well, I'm sorry. That's what I heard. If I was misheard you say that, or maybe
can I correct you?
Sure.
So the interception from Travis County Sheriff's Office prohibited me from maintaining my job.
You can correct
so I don't have a
me
job.
about what you said about the $160,000. I
was making $160,000. I had gotten the job as a high-end job. Travis County Sheriff's Office arrested me, which prohibited. I got out of jail and lost a $160,000 job.
You lost that job. Okay.
Yes, ma'am.
Right. Well, that's great. Well, I tell you what, then, based on that information, I will amend my order, and I will give you until May 31 to pay the attorney's fees. I'll give you a little more time to get that paid. So I'll change that based on that information. And thank you for clarifying that. I will order the payment of the $2,600 on or before May 31, 2024. I do find that the plaintiff has a superior right of possession and will grant immediate possession to them because they are entitled to it. And I don't think there's any I think the evidence is clear that you can't rent a place, not pay the rent, and then continue to live there. So I do believe that they're entitled to immediate possession. And I believe that the rent writ requested by the plaintiffs in that regard for immediate possession is both justified by the evidence and appropriate under our law. Let me just check and see if there's anything else. I think that's everything that covers all of the requested relief. To the extent that Mr. Way has counterclaims on file, they're all denied because they are either in excess of the court's jurisdiction regarding the 10 million or $200 million in damages that he's requested for what might be considered tort claims. And then with regard to the criminal claims he seeks, obviously I do not have the jurisdiction to deal with those matters, but I think he understands that if he wishes to pursue those, he has other avenues, both in the federal courts or in the prosecutor's office or the police with regard to other matters. And I think he understands that. We've explained pretty thoroughly the right of appeal that each party has if they don't appreciate this proceeding and the rulings that I have made today. So here are the next.
How long do I have to appeal?
I can't give you, that's technically legal advice, which I'm
5
not
days?
allowed to.
Thank you.
I said I am not allowed to give you legal advice, and so I can't answer that question.
No worries. As soon as this is done,
That
as soon as
up
it's
to
done.
up to you. I would say sooner the better, but I'm not allowed to give you advice about your deadlines because that's in the nature of advice which judges are prohibited from giving. So I can't tell you the answer to that, but I can generally say that the more quickly people do things, the better.
Gotcha.
So
We're going higher for sure. Thank you.
okay, so here's the next step then that what will happen. Ms. Du Bois is going to be directed by the court to prepare the documents because she represents the plaintiff and the plaintiff is the prevailing party. Typically, we would ask the prevailing party to draft the documents. She will do that. She will send them to you, Mr. Way. She's going to send them to you by email. Ms. Du Bois, in your email, please indicate that you need them back by within 5 days. So Mr. Way, I'm going to give you 5 days to review the documents that she has sent to you. That should be enough time. You probably can do it sooner than that. I don't know what you may want to talk to somebody about it. I just want to make sure you have enough time to think about it, review it, make changes or whatever. If you have changes to the document because you believe they are inaccurate, then redline the copies that she sends back to you and tell her, you don't want it to say this, you want it to say that, or whatever. So send her what you think that document should say if you disagree with what she puts in there, okay? Once you hear back from him, Ms. Du Bois, then send those documents in to Ms. Burks, and then she will send them to me. I will review them and I will sign the document that I think accurately reflects my ruling today. Okay. And it should be a complete and final order, and be sure you include that language in it so that it's final and appealable and can go up to the next level. So, Mr. Way, she's only going to wait those 5 days. If she hasn't heard from you, then she's going to send that draft over to Ms. Burks, who will then send it to me.
I have not been able to communicate with Aaron not one time since the trial. Or
it's just by email. It's just by email. You don't have to have
I have not been able to communicate with her.
Yeah, she is being directed to draft the document. You are being directed to send her your changes if you have any. You may not have any because she may get it right and correctly reflect it. Now, let me say 2 things about that. One, if she doesn't hear from you within those 5 days, she's going to send it on. If she does hear from you within those 5 days, she's going to either make the changes you've requested because she's agreeing to them, or she's going to then send to Ms. Burks her draft and your draft. You are also welcome to send her draft and your draft directly to Ms. Burks. You can do that too, as long as you do it within those 5 days. So everybody can send whatever they want to Ms. Burks, who will then send it to me within that 5-day period after Ms. Du Bois drafts them and sends them to you. I'm going to direct her to get that to you by Monday of next week, March 4th. Okay, so it's going to take, it shouldn't take her too long. She's required, can you get it to him by Monday?
Runner, I can get him to him in the next 5 minutes.
There you go. So no later than Monday, Ms. Du Bois is going to get it to you, and no
You
later
have
than
5 days, Aaron. Calm the hell down.
excuse me, and then Mr. Way will have until Friday of next week to make his changes. Everybody by Friday of next week must send what they've received by then to Ms. Burks. Okay?
So then after that point, you're gonna initiate your order, and that's gonna come from you
After
then, right?
that point, I'm going to
Mhm.
review what you have both submitted to each other. You're either going to submit an order that you both agree is correct, or you're going to say, I want this language, and the other one is going to say, no, I want that language. I am going to then review them both, and then I am going to sign the one that I think accurately reflects my ruling. And if you both get it wrong, I'll probably draft my own. But that seems unlikely.
I just want to clarify, the document coming from you, the judge, that's going to be the final document that I can appeal,
That's going to be the final order on the merits of the case that reflects what I've ruled today. That's correct.
Okay. And so when you initiate that.
Just to be clear, here are the deadlines. Ms. Du Bois has until Monday, close of business, to get the order to you. You will have until, I'm going to adjust that a little bit. I'm really going to give you 4 days because I want you to get it back to her by the end of Thursday of next week. So if you want to tell her you got changes to it, you have until the end of the day on Thursday to make those changes. I want by noon on Friday of next week for you all to send to Ms. Burks what you believe is a correct reflection of my ruling. Okay?
Okay.
I want that to Ms. Burks by noon so that she can then send it to me and I can look at it and get it back to you. I may or may not get it back to you that same day, depending on when I get it and what else I'm going on. You know, maybe a hearing that day, I don't know. But I want them to Ms. Burks by Friday of next week so that I can then review them and sign the one that I believe most accurately reflects my ruling. Now, Mr. Way, Ms. Du Bois, these orders, this order that we're talking about should include only those things that I'm ruling on and the request that I'm granting, the request that I'm denying, all that we've discussed today. Mr. Way, when you react to what she writes, that is not an opportunity to re-argue the things that we've talked about, right? It's just an opportunity to make sure that what she puts in that draft order accurately reflects what I've ruled, right? To the extent that you want me to reconsider the jury trial, I'm not doing that. That's order stands.
Yeah, we're going to escalate. Yeah.
That's fine. That's okay. I'm just saying that the purpose of this order is just to reflect what we're doing, not an opportunity to re-argue. You can re-argue that in another case, right? In another.
Gotcha.
This order just needs to say, here's what Livingston is ordering. And that way, when you go to the next level, that court can say, oh, here is what Livingston did. She got it right. She got it wrong. But here's what she did. And so this order needs to say what I did, not what you all think about what I did, right? Not whether you agree with it or disagree with it. Just is this what I actually ordered? And that's all that needs to be in that order, not your opinion about it. Just did I accurately say denied, granted, ordered, amount of money, amount of interest, attorney's fees, whatever, right? Speaking of attorney's fees, in addition to the $2,600 that's due on or before May 31, 2024, the appellate fees testified to in the event of appeal, those are granted as requested. And so that should be included in there as well. So again, we just need an order that says, okay, we had a hearing on February 29, 2024. Here is what Judge Livingston ordered. Yes, no, granted, denied, money, interest rate, so-and-so. That's what she did. And then I'm going to sign that. And then if anybody wants to appeal that, now the appellate court will know exactly what I did. And then they can decide, they can grade my paper, right? And decide whether I got it right or wrong, but at least they will know exactly what I ordered and what I did not order. Okay?
Your Honor.
In the meantime, I'm going to get 2 things because the writ of possession is going to issue immediately. You can send that over to Ms. Burks today. You don't have to wait for that for next week. You can send that today because your client is entitled to that today. Send that to Mr. Way and then send that to Ms. Burks today. Mr. Way, if you have objections to that.
I have objections to that.
No doubt about it. But send your objections to Ms. Burks as soon as you get that. And I will wait until later in the day to sign it, just to give you an opportunity to make whatever changes you think need to be made to it, but I will sign that one today.
As far as the eviction goes?
I will sign the order for immediate possession today because they're entitled to that. And then you have avenues that you can take related to what you want to do next about all that. But I want the order because they're entitled to it today. I want that one signed today. The other order can wait. Okay?
What about the property then?
You're asking me questions related to legal advice that I cannot give you. So I can't give you legal advice.
Okay, so I can appeal this, right?
Absolutely. Well, I believe that that's also a question about legal advice, but I think I've already said that my decisions are subject to being reviewed by a higher court. That court is called the Third Court of Appeals.
Okay.
Okay?
Let me get on my appeal then.
All right. Take care, everybody. It's nice to meet you all. Mr. Wade, don't forget on those other cases, you need to visit with the opposing side for that. And then
Judge
schedule that.
Levinson,
I've already talked.
Hello?
Okay, I can hear you now.
Okay, I was just telling Mr. Wade to be sure to deal with, talk to Ms. Burks on those other cases. And I believe that concludes our time today. Thank you. Good luck to all of you.
Your Honor,
And thank you, Ms. Duet, for taking it down for us as the court reporter. Thanks to Mr. LaRue for handling the Zoom call for us. Appreciate your assistance as well. You all have a great day and we are adjourned. You may be excused.